Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh, and I finally have my favorite guest, Bruce from Oregon, back.
Oh
He's been
boy.
gone for a little bit. Um, Nanny X3, before we get started, I just want to say thank you for becoming a channel member because I see right there you just did. So appreciate you. And if you head over to the members tab on my YouTube page, you'll see lots of members only stuff. And I'm going to keep doing members only streams and videos as I go. So, somebody says, what is the new problem with Stephanie Jones' subpoena? I don't know about that. I did a video about that yesterday, but it's not like a problem with it. It's just people don't really understand. There's a lot of back and forth. So our friend Omar, the Tilted Lawyer, is saying he's going to join us too, so he can probably explain some of that.
Very good.
But yeah. Bruce was a busy guy the last week or so I don't know if you actually got to hear any of that protective order hearing that we're going to talk about.
I've been watching all the videos. Yeah. So I kind of fake retired, and I feel like I'm busier now than when I actually had a job.
Oh man. Omar says, "Don't ask me." Omar, hurry up.
Wow.
I'm not going to say that. It's too early in the stream for me to cuss. So
we might have to ban him.
Yeah, probably. Anyways, so you were busy last week, and then I know earlier tonight I watched your pre-bachelor party stream, which is always fun. Usually I'm at my mom's house on Monday nights.
Yeah.
So we watch it there, and then I taught my mom how to comment on the YouTube mobile because they can do it on the computer, my parents, but they can't do it on the phone.
So it's pretty wild. You know, our buddy Dave Neal used to do pre-show lives and post-show lives and all this stuff.
Well, he's got a whole baby now, so
he's got a baby. He's got a podcast. He's so busy now. He doesn't do the live streams. So a bunch of people still wanted to have live streams. So I'm just It's like I'm just the guy, you know, in the food cart making nachos, and everybody else is just having a party.
For sure.
Yeah.
Well, you know, Dave, every time I text Dave and I'm like, hey, Dave, we're about to stream. If you want to join us, that's fine. He sends a picture of him with a baby on his chest.
Yeah.
It's like, okay,
sure.
Never mind.
Especially this time of night. Yeah.
I mean, August can come and you can go to bed if you want. I'm not sure how that would end up. But yeah. Anyways, guys, I got some. I wanted to go over this protective order hearing after the actual hearing happened last week. And Bruce, I don't know if you saw, I'm sure you did, that Dave and I were kind of in this shit because we've never covered a federal case before. So neither one of us knows, like, oh, you're not supposed to, you know, put this on YouTube because it's like it's open to the public. Here's the phone number. Everyone can, you know, hear it. And so, like, neither of us was thinking like, oh, this could be a problem.
You can listen to it. They just don't want you to. It's like YouTube's a big VHS player. And it's like when you record the Packers game, it's like, well, you're not really supposed to do that. So, yeah, it's like you're just supposed to watch on Fox or CBS or something. I get it.
Yeah. No, I just... I don't know, because the only court case I ever covered was Laura Owens' case, which is a family court case that I covered in Arizona in person with a camera, and the judge said okay to that. So I assumed when the judge said this is a public audio that it was allowed, and obviously that caused some problems. I was like, oh my God, what have I done? And of course, Dave, you know, had the same deal, but on a larger scale, because Dave's, you know, got a 10 times the following I have, so he got much more kind of backlash for that, but he dealt with it pretty well.
Even with family court, you know, they can often say, hey, you can't get the video or something, because obviously in a lot of family court cases, there's children involved and a lot of sensitive issues around the children, so they don't want people just having the video of the raw court footage. But of course, with the Owens v. Eckerd case, there's no demonstrable children, so
no, not any real children anyways. Maybe next time, you know, because we know there'll be a next time. If Rachel Mitchell doesn't charge this woman, there is going to be a next time.
We never saw any real children in that case, so
nope. Sarah Dawn, thank you for the 5. Boop, my favorite dynamic duo. Thank you very much, Sarah.
There we go.
We appreciate you. All right. So yes, like I said, these old fogies should be more clear. Listen, we are not experienced. It wasn't their fault. So it's, I don't know. We're going to call it a no fault situation. We are right now. So Okay, I have these very detailed notes from the court hearing last week because since I was planning on streaming it and I have the ADHD real bad, I asked someone else, hey, can you take some notes for me? Just like take some key points or whatever while I'm doing this, just in case. And they ended up sending me like 12 pages of notes on Word. So we're going to
Yeah.
go through some of this and talk about some of the main points. And we'll go over that with Omar as well when he joins us. He's running a little late. Let me just scold him really quickly for that.
Yeah. Yeah, that's what I always used to do back in my job in corporate America. We'd have these, these things where people would all get together in the same location. We'd have a big face-to-face sort of summit. And it was always very good if somebody could take detailed notes.
Yeah.
Maybe somebody who wasn't involved in all the conversation at the time.
Mm-hmm.
Those
Well,
were
I
always
was
great.
busy. If you guys are watching that live stream where I was covering the hearing, I was busy learning ASL for bitch, stupid, shut up, all kinds of stuff. Like while on the screen, I was like, I don't know what to do. I don't want them to just stare at my face. So let me find something else to do. So now I know how to say stupid bitch in American Sign Language.
Oh my.
Yeah, right. Okay. LP, thank you for the 10. If the judge exempts A-listers, i.e. Taylor Swift, from text messages, can Justin's lawyers appeal? So if the judge rules on this, I'm pretty sure that's just how it has to go. Appeals are pretty much for like if the case doesn't turn out how you wanted it to and you think something was unfair or you think something needs to go differently, you can appeal to like a different or higher court. Like there's an appeals court and then there's the Supreme Court and all that. But it's not really for smaller motions like this. If the judge rules on something and says this is protected or this is denied, this is granted, it's pretty much the judge's call. So yeah, as far as like the protective order goes, whatever the judge says is going to be how things are handled from here. We can only hope that they don't grant the more restricted protective order because that would obviously suck for the public interest, but yeah.
Yeah, and I mean, like we saw in the Owens v. Eckerd case, the judge, there was a sort of February early hearing before the final June hearing, and the judge said, look, if there's material that needs to be redacted or withheld from the public, we can treat those things sort of a la carte, right? Like on a case-by-case basis, as opposed to just blocking everything. So the judges theoretically have some leeway to be a little bit more selective about what they would redact or seal up. Yeah, hopefully.
Well, as far as the redactions and stuff go, I know a couple of the things we'll go over tonight of more interest were the text messages between parties or non-parties and non-parties like Taylor Swift and Blake Lively, which is the big one, I think, and then the mental health records of parties involved, which I have some objections to for specific reasons. Like I won't get into them too much right now. We'll get into it later. But as a person who works in psych, as a person who's seen a lot of cases involving psych patients, like a lot of cases involving psych patients, I have a lot of objections to what they said. And we'll get into that. I think that is it's an overreach in my opinion, because you don't need a special protective order for that kind of thing. It's just that usually mental health records don't become available to the public and you don't need to block everything or block a larger scope of things to achieve that goal. So, but yeah. All right, let me see these notes here. So they started out talking about the PR firms. So here's the thing with the PR firms. We have Leslie Sloan and Vision PR. That's the PR firms for Blake Lively. Then we have Jennifer Abel and Melissa Nathan, who currently, I believe, represent Wayfair and Justin Baldoni. And then there is Stephanie Jones and Jonesworks, who previously represented Wayfair and Justin Baldoni. But Jennifer Abel used to work for Jonesworks. And in the middle of this case, left Jonesworks and started her own business. And there's some dispute about whether or not she, broke or violated her contract while doing that. Melissa Nathan, I don't think she ever worked for Jonesworks per se, but she worked with them on some stuff. So they started out with this protective order stuff regarding the trade secrets of the PR firms. Bruce, I don't know if you heard anything about that, or how caught up you were on that. Oh, good night, Sarah.
I'm not too familiar with that.
Okay. So they started saying basically, okay, and there's some quotes in here that I'm going to read. Not this one. Let's see. Give me 1 second to scroll down to that. Oh God, and I forgot about this. And I'm reading these notes and I forgot about this already. Somebody said, and surely somebody like Leslie Sloan and Vision PR who have been unnecessarily dragged into this litigation to have to then disclose to their competitors information as to who their clients are and the sensitive nature of information, we consider that to be something that would warrant the, and again, Your Honor, this is not absolute. There is a mechanism to the extent something is designated AEO. And on the other side, it does not believe it should be. There's a mechanism for the parties to confer over that. This allows discovery to flow out without the alternative that the other side has proposed would require us to hold that back and then come directly to you and have that argument immediately. So they're talking here about AEO, which is attorney's eyes only. And I believe this argument that they got into here was regarding trade. They called it trade secrets. But then the other side came back and said, well, publicists, which publicists represent which clients is not exactly a fucking secret. This is not, and then
You mean for clients that are in the actual litigation, not just random clients?
Yeah, no, they're saying basically we don't want to expose our business with XYZ person or whatever, which is kind of strange. I'm just kind of I don't understand why that would matter at all. It's not like they're, getting access to all of your records and communications between all your clients. It's just it's within a certain scope. So when I heard that at first, I was just kind of what are you talking about? What attorney's eyes only information would need to be had?
So I mean, in the tech industry, a customer list, if I work for a tech company, which I did, the list of customers that company has is not that's not information that even I as an employee had access to.
Right.
It's very,
yeah.
You got to treat customer information for privacy reasons separately from other corporate confidential information.
Mm-hmm. Let me see if I can find Macaulay here. Give me 1 sec. Okay. So Macaulay, on behalf of Leslie and Vision PR, said what I just read to you guys, and then also, let's see, it's common in these types of cases because it's absolutely necessary when you have competitors who could be receiving that information, having that heightened level of an attorney's eyes only designation to protect that sensitive information is critical. Okay. There's a built-in safety net where they can confer over that, and to the extent there's any concern, it can ultimately be raised by the court. But at the outset, it's going to help facilitate discovery because we can exchange information, but yet protect our client's interest, and this goes on both sides of the fence, frankly. Let's see. These publicists run on both sides of the V. So... Okay. They are in this space and they have a number of competitively sensitive information they would want to protect, Your Honor. And this, I have a lot of quotes here. You asked for some information about what that would be. Certainly, these publicists have trade secrets they want to protect. They have their clients' business plans, strategies, marketing plans. I'm familiar with Austin versus Moda. I decided some time ago, but I keep recalling. I don't know if that note was right there. So you mentioned trade secrets. What else was on your list? Other plans, that was the judge there that said trade secrets. What else was on your list? The lawyer says other plans, business plans and strategies, marketing plans, any discussions in the documents concerning other clients or non-public projects or leads. And I believe I started with trade secrets. Okay. So again, I don't understand why this is a specific issue in this case. I feel like we've seen lots of celebrity cases, especially where publicists are involved and stuff, because that's how the industry works. But I've never seen a special attorney's eyes only designation for stuff like this. So
Well, certainly for things like future business plans or future endeavors, one of the cases they cited, I remember they mentioned, was something like it was related to like maybe it was like the Pulp Fiction movie script prior to the movie being released, right? Like you wouldn't want things like
Hmm.
that just sort of out there.
Hmm. Well, I'm sorry. Omar says he'll be
Although,
on in a bit.
in this case, what would they be talking about? Maybe plans related to, if the author of the book that this movie was based on,
Yeah.
there's other books, if they have other plans for future movies, those plans could be considered trade secrets.
Hmm. So I'm not gonna lie, I don't understand a lot about trade secrets and businesses, but like I said, Omar, who's going to join us in a bit, is going to answer some questions about that. Why don't I just skim on to, let's
Mhm.
see. Okay, this is Stephanie Jones, attorney, says he would certainly join in everything that she said, which of course they would, because Stephanie Jones and Blake Lively's, PR, Sloan and Vision PR, they're probably in it together at this point. There's some questions about subpoenas and how subpoenas were obtained and how people knew to get subpoenas and stuff like that. But at the end of the day, it does seem like, and I know this is heavily disputed, obviously, in the comments of my recent videos, um, pre-litigation subpoenas, people are like, how do they get this information? How did Blake get this information? Pre-litigation subpoenas, from what I've seen, can be obtained in New York and in California if you can prove that you have good cause for an action. But people are then saying if a subpoena was obtained by not Leslie, sorry. I keep wanting to say Leslie Jones because of SNL, Leslie Jones, and there's a
Oh,
Leslie
right.
Sloan. There's a Leslie Sloan and there's a Stephanie Jones. But Leslie Jones is one of my favorite comedians. So
I
it's, it's,
know.
it's a mind fuck. Anyway, so Stephanie Jones could have obtained a pre-litigation subpoena in New York Supreme Court before filing her lawsuit in New York Supreme Court. And let's remember that her lawsuit did not originate in this federal case. It was moved to be a related case to this federal case, but
Mm.
it started in the New York Supreme Court. And in the New York Supreme Court, you can, in fact, get a
Mhm.
subpoena based on or for pre-litigation purposes. And so it's possible that that did happen. That's where the subpoena came from. However, people ask then, how did Blake Lively get that information?
Mm.
Um, and there's some specific circumstances under which you can get a pre-litigation subpoena in California. So there's some question about whether or not she did that before filing the CCRD. However, because with the CCRD, she filed the precursor, which was basically her first complaint. Um, However, we don't see, obviously, that these things happen. So people are questioning it because we can see so many other things, like all of the documents in this federal case, pretty much, except for I raised you guys. You can't see the subpoenas. We can't see the subpoenas that they sent for the phone records. We can't see the subpoenas they sent for discovery. We can't see any of that. So it doesn't mean there's no subpoenas that were legally filed. It just means we can't see them. Um, Now, with Blake, to get the text from JonesWorks after JonesWorks would have filed the pre litigation subpoena, that's the sketchy part. So, how did that happen? How did they know to do that? And based on the messages we've seen in these filings, it seems like Stephanie Jones saw those text messages off of Jennifer Abel's old phone, the one that the company owned, and she then kind of badgered Jennifer Abel, Melissa Nathan, and told Leslie Sloan about it. So the question is, like, did they come across that information legally? Like, did they actually subpoena that information? Or did somebody tip them off and say, hey, I got all of this stuff and you got to go after these people and, you need to then go this route to do that. So I don't know. There could have been something sketchy happening there. So yeah. Well, that's what not Eminem's mom. Well, whose mom are you? Says, how would Blake's team know to ask for the messages? That's what I'm saying. That's where I'm saying the sketchy stuff happens. It all kind of comes back to Stephanie Jones and how Leslie Sloan and Blake Lively knew, hey, we need to subpoena these records from Jones Works, even though Justin... Go ahead.
This sort of schism between the Wayfarer PR firms into two different companies, did that all happen previously? Or was it happening at the same time? Or do you understand the timeline of that?
Kind of. One more time. Ask the question.
So there was this schism, right, between the original Wayfarer PR firm and it turned into a second firm that took over the client. Did that happen earlier or at the same time, or what's the timeline on that?
There's some debate about whether or not Jennifer Abel was fired from Jones Works or Jones Works or she left Jones Works, and I think that's where the discrepancy comes in. And it's it depends on whose account you're reading. As to when this happened.
You know, they're all down in Hollywood, right? Or what? They're all working in Hollywood, basically. And I worked in tech, and so is Silicon Valley or whatever. I mean, these type of places, whether it's Silicon Valley or Silicon Forest or whatever,
there's a Silicon Forest.
Yeah, like Oregon is kind of considered, or Seattle a little bit, but the Pacific Northwest. But in any case, when notable people leave a company to maybe do a startup or they join a startup, people switch from one, because a lot of times these companies, they have offices. They're like, instead of just waking up and going to work in one parking lot, you wake up and go to work in the parking lot across the street. Like you change, they're all there. Everybody goes to the same restaurants. Everybody goes to the same happy hours. And you just kind of you can learn a lot of this stuff, right?
I mean, I'm feeling a little left out.
I'm feeling like this, business change may have been the catalyst for some of this information. Being sort of anecdotally out there.
Well, for the change, especially people think that it's Stephanie Jones took the phone that belonged to Jennifer Abel when they split. But the thing is, no, it actually belonged to Jones Works, which is her company. And so when Jennifer Abel left or got fired or whatever, they had a right to keep the phone. The thing they held hostage was the phone number, which for some reason, I guess publicists may do this a lot, apparently based on comments I've read, but for some reason she was okay with using her personal phone number and attaching it to the work phone. So that was the only phone she had, and that was the only phone number she had, but the phone number was used for different purposes on the work phone. So she was sending personal texts to Melissa Nathan and some other people, and that's why those messages are out in the filings. Is because apparently Cellebrite, the forensic tool you use to extract information from phones, is what police use in investigations and stuff like that. Cellebrite does not require you to have a subpoena to get information off of a company-owned device for internal purposes.
Oh, I see. Yeah. Because you're the employer and it's your corporate property, so you can just have somebody. It's sort of like if you thought the hard drive or something or the flash drive was malfunctioning, and you needed somebody to go try and recover data, you could just do that.
Right. So it all just comes down to whose story you're buying, and was it actually her right to take the phone? Was it actually Jennifer Abel's phone? And we haven't seen their response yet, so we'll have to see some evidence of, hey, no, that was my phone, not yours, or something like that to combat it. But, it's very complicated, I think, and especially because in her filing, Jones said that she did obtain a subpoena. So maybe they, got the information off the phone for internal purposes and then decided we're going to take legal action or something like that. I don't know. Maybe they just went the legal route right away and they got a subpoena for that information. But then how did Blake and Leslie Sloan know to take that information for them, that kind of stuff. So there's just a lot of back and forth about that we're not really going to understand for a while because we can't see subpoenas in the public record. So I would love if Omar was here with us, but he's taking freaking ever, dude.
I think the pro tip for the rest of us is just try to keep your work phone and your personal phone separate. You can.
I would never allow a company to force me to use my personal phone for business purposes. I
Mhm.
say terrible, awful things to people on my personal phone. So,
Oh boy.
oh man, I mean that in the best way possible.
Most of those things are to me too. So,
Yeah. Do you think my boss should read our text thread?
oh no.
Right. Yeah. Right. Okay. Anyways, let's move on from the PR stuff here.
Yeah.
I've just scrolled down in the notes a little bit, so it's gonna take a sec. Okay. All right. So they start talking about the security firm for Blake and Ryan. And they're basically saying that Justin and a Wayfarer would want to subpoena the records of their security firm, and which didn't really make sense to me the first time, and it definitely doesn't make sense to me the second time. So I'll read the direct quotes here. Oh, no, let me make sure I don't start with that jargon. Okay. Hold on. No, we're still talking about Abel and Miss Nathan here. Oh, no, here we go. On behalf of Miss Lively and Mr. Reynolds, Your Honor, of course, all the parties agree that the court should enter at a minimum its model protective order, which is the one that was proposed by Wayfarer, endorsed by Wayfarer. And so the creation of the attorney's eyes only category that we're requesting is actually built off of that model protective order. The model protective order already protects information of a personal or intimate nature regarding any individual. And so what our proposed attorney's eyes only category seeks to do is to add an extra level of protection for materials that would fall in that category, but that are especially personal, sensitive, or proprietary that would cause irreparable harm if it were misused or revealed publicly. I don't know what they think we're going to do to them, but okay. And like after the fact, like apparently they're going to argue here that like they don't need to know information about their security and stuff like that, but it's like that stuff already happened. I agree that it's a little invasive, but also like what danger is going to come to you from that? But okay.
Yeah, and I mean it depends on the context, right? Like someone is in chat was saying it could be a witness to these events that were described in the complaints.
Okay.
Or the countersuit. So, for example, I remember they had a lot of these meetings or conversations in places, right? Like trailers and penthouses and all these things. You may have security personnel there who may be able to corroborate conversations and things like
Okay.
that.
Yeah. So they're basically saying that if they don't have the AEO designation, that people would see like specific timelines or locations of their security firm, I guess, or like Justin and a Wayfarer parties would see that. But let me keep going just to make sure I fully understand here. The attorney keeps going. They said, I understand the court seems like it's primarily interested in two aspects. One is the reason why the confidential designation is insufficient to capture all discovery information, why an AEO, attorney's eyes only, designation generally is needed, but also specific examples of the materials that we would prefer would qualify as AEO. So I'll start with the second and then go to the first. And let's book the first, a different ordering. I'll leave it to you. Okay, so that's the judge. Okay, so as far as some specific examples of the type of materials that we would imagine that would be subject to discovery and that would pose kind of irreparable harm if disclosed, one example is specific security measures that Ms. Lively and Mr. Reynolds have taken in order to protect themselves and their families from this retaliatory campaign. Okay, but this retaliatory campaign is apparently just like internet slander.
Yeah, I mean, I don't think their security guards are like,
Right.
I don't know, like a bodyguard can't protect me from Instagram.
I mean, they can try. I feel like you probably
weird.
don't even. Do you even use Instagram that much?
Like if they were worried about like, oh, we have a security plan, like a document, and the document describes like where we station security at someone's private residence.
Yeah.
Obviously, you don't want people to know that.
Mm-hmm.
But when you're talking about like, well, somebody wrote an article on the New York Times, Medium.com. Somebody did a YouTube video. What does that have to do with a security guard?
Right.
I'm not
Yeah.
sure. It's interesting.
Let's see. What do we about that? We got through security protection. The third party subpoena asks for all documents and communications concerning to or from Miss Lively and Mr. Reynolds. We will, of course, lodge objections to that subpoena, but in the event that production is necessary, we don't see any reason why the parties themselves need to know the specific details about Miss Lively and Mr. Reynolds' security measures that they put in place. And then the judge interrupts them and says, "Are you saying that you believe Mr. Friedman's clients present a risk to your client's security?" All right. And then they
exactly. I mean, that gets back to the tactical nature of what are we talking about here? Are we talking about like, I don't want somebody to know what hours a particular security guard works at my house.
Yeah.
Versus, if they were doing something shady online, maybe they don't want that to get out.
Right. Let's see. Mr. Friedman presents. Are you saying that Mr. Friedman presents a risk to your client's security? Okay. And then they said, Mr. Friedman, of course, is an officer of the court and subject to the professional rules of responsibility, as well as additional obligations unique and specific to attorneys. Unlike in typical cases, the parties in this case, on both sides of the bay, include people and businesses whose entire living is made off of providing information to the press and content creators. God damn it. I wish they would stop doing that. Like pretend that you haven't used the same mechanisms for your benefit. You know what I mean? I'm not
giving information to you, Lauren. Oh my gosh!
Directly, Ryan Reynolds gave me information directly. All right.
Tell him my mom says hi.
Somebody call the judge. I'll tell him about your mom, I guess.
I'm still waiting for those Blake checks.
Dude.
Whatever checks.
Yeah, I've been accused of getting checks from Justin's side once. I was like,
know, right?
How much and when do I get it? Like,
I can buy some eggs.
Imagine just like allowing people to have independent thought and not accusing them of being paid butts. I don't know. Anyways, moving on. I'm not intending to be pejorative. It's just the reality of what they do. They make money and sustain relationships by trading information with them, content creators and press, I guess, and having techniques for doing so off the record and on background. And in fact, a particular note in this case, the defendants themselves have bragged in text messages about being able to do this in an untraceable way, of being able to publish information without fingerprints, and also having individuals who will, quote, do anything for them and who hate Miss Lively. I mean, no doubt there are people who hate Miss Lively, but I'm not sure this has anything to do with the protective order issue. All right. So we'll pursue further evidence of this through the discovery, but the evidence so far demonstrates there's a significant risk, unlike others that have been before this court. I think it's worth noting that defendants appear to be operating on an unlimited budget. So I guess they're talking about Sarowitz. That really renders the traditional mechanism of using sanctions to control parties meaningless in this case. Defendant Sarowitz, has committed to spending $800 million. I think it meant $100 million, but she mistyped this. $100 million to ruin the lives of Miss Lively and her family. And the amended complaint includes a separate quote saying, in which Mr. Sarowitz says Miss Lively and Mr. Reynolds will be the equivalent of dead bodies when he is done with them. I mean, that's a lot, but again, I don't think that like somebody speaking in hyperbole or metaphor or symbolism or whatever is really a good reason to get a protective order when the regular people, people who go through stuff like this, we all have to have our shit subject to public opinion. So just because you're rich and powerful doesn't mean that you're more special, in my opinion. So
yeah, petitioner is not special. We've seen that before. The other thing is, I think a lot of those quotes are out of context, right? Like, that's what it seems like.
Oh, they're pretty in context because I got timestamps, but I'm not showing them on the screen.
No. I mean, the
Sarowitz
your quotes, but
the
the arguments they're making are a little out of context.
So the Sarowitz quote, Omar said he thinks that it was recorded because it's very specific the way they quote Sarowitz in the amended complaint, but we haven't actually seen any evidence of or even a claim of having a recording, so there's kind of some up in the air stuff about that. As far as the rest of it, let's see. With like the content creators and stuff, obviously there's no quotes there. So it's just they're just speculating. Basically, they're just saying like stuff's not going our way. So basically, something's happening here that's something's afoot, and it's just not true. We just read the papers, and their side doesn't make sense.
Sometimes a foot is just a foot.
Yep. Sometimes it's 2 feet, bro.
Wow.
All right, let's see. So we got through that. Particular notes, Mr. Sarowitz. Okay. We submit that threats like this, Sarowitz alleged threat, raise the question of whether traditional sanctions could possibly deter the abuse of highly sensitive, personal, and intimate information that many parties and third parties may produce in this case. And really, no amount of sanctions could unring the harm that we think would come from this quite narrow category of what we think would fall into this AEO designation. Why don't you get back to now that you answered my question? Do you mean by the quite narrow category? Because it appears that the Wayfarer parties already are privy to a fair amount of personal information about your clients. So what is it incremental that you think poses a particular risk in this case? Then the lawyer says, okay, so I'm going to get to the category in one quick second, but I just want to make one final point, which is directly relevant to that question. There is an insatiable appetite for any information about this case, no matter how salacious it is. We've seen even the most benign and routine information become tabloid fodder. And just this week, for instance, Your Honor, the Daily Mail published a story based on an insider source with information from Mr. Baldoni's legal team about the, quote, first group of potential witnesses who Baldoni's team want to hear from. They're referring to the article about Taylor Swift being that first group, because I covered that. Who have been contacted but not yet scheduled. So even the prospect of discovery, and so it's not a stretch for the court to imagine the harm that could come from actual discovery information being placed in the wrong hands. The thing is, we don't actually know who tipped off the Daily Mail. We don't even know if they were telling the truth. It just so happens, which I feel like is not a huge leap, that Taylor Swift was contacted for deposition. So they're saying no matter how salacious it is, but the fact is it's not salacious. It's an objective fact, as you just so aptly provided that information to us. So I don't really understand what the outrage is here. They're saying there's an insatiable appetite for any information. Okay, but that's not a crime. Like, yes, it's a high profile case that your client started and your client made public by going to the New York Times and having the story just blown out there. Without ever trying to resolve anything, apparently behind closed doors. There were no real HR complaints. There were no, meetings or anything. They basically were just like, this guy needs to go to the basement. I'm taking this movie now, or I won't promote it. Stuff like that. So it's just like, I'm looking at what this lawyer said, and I'm thinking like, this is the most mundane piece of shit ever. When you say, oh my gosh, well, we need extra protection in case stuff gets in the wrong hands because the Daily Mail said Taylor Swift is going to be deposed, as if we didn't all fucking know that already.
Yeah, I mean, a witness list or a deposition list isn't exactly salacious.
No, it's not like we have a whole list. I saw 3 or 4 names mentioned. One was Taylor Swift, and there were 2 WME execs. And another one, I can't remember who it was. So, but it was hardly salacious.
Right.
Yeah.
Did he actually answer the question after that additional comment?
Who, the judge?
No, because the judge had asked this question, right? Like, what specifically are you talking about?
Oh, the judge did ask that, and that's what the lawyer said.
And the lawyer's like, I just want to make one more point, and then I'll answer your question. Did he ever answer the question?
The judge says, and so what kind of information? We've talked about security measures. Another category of information that I do not have access to right now is medical information, okay, including relating to the physical and mental health parties. So this is the lawyer again. So the judge said, what kind of information? She's saying security measures, and then also medical information, including physical and mental health of parties and non-parties, privacy interests in protecting information about health. I mean, that's everybody, wants that, obviously, and I feel like we all have the right to that, except if you bring a court action and you say this person caused me this mental distress or this medical harm, you better fucking prove it. You know what I mean? So like, that's not like, if you bring that action, you're saying this happened to me, you need to produce the evidence. I don't think that's that much of a stretch. And obviously, like, that stuff, like I said, in other cases where there's mental health problems and there's physical health problems and damage and stuff like that, I don't see those records being made public. So I don't think they need a special snowflake
Did we even see a
designation
request
for that.
Did we even see a request for that medical information? I mean, that's
No.
almost like,
Yeah.
again, it reminds me of this Owens v. Eckerd case where back,
Mhm.
in the February hearing, Owens' attorney was like, well, there's specific mental health topics where we don't want these records released. And it was sort of like, I don't remember the respondent ever asking for that. Like,
I mean, you
so
can
they were
ask.
they were almost
Right.
telling on themselves, right? Like they were almost like, well, you're bringing it up.
Well, yeah, exactly. And then also, this is it's like with mental health cases and stuff like that, even here in Florida, just state cases, like, they're obviously not involving any celebrities or anything like that. It's like, even when we know there's mental health stuff going on, or when there's a competency hearing or something like that, we don't get to see the evaluations. Like, we don't get to see those detailed records. I'm absolutely certain in a federal case involving high profile celebrities, you can request to have that stuff if it's not already not readily available to the public. You don't need a special, like I said, special snowflake designation for that. Like, it's not a thing in my knowledge. And we'll have to ask Omar when he gets here, because he's the only one of us that's a lawyer, unless you're a secret lawyer. But
Salacious medical records. Maybe it's receipts for getting this taint tattoo.
you. I forgot about that until you just said that, and I'm gonna hurt you for it later. Help me. Okay, anyways. Yeah, anyways, that's just like, why do you feel like you need extra special protections that the rest of us in this country are not afforded? Even people who really need that shit. So I don't know. I don't care, and I'm gonna be honest here. I don't give a fuck if you have a little depression and anxiety because you're going through some shit, because that's just part of the American dream now. Like, I'm sorry, but we all gotta deal with that, and we all are subject if we bring these claims in court, and if you make accusations, especially false ones, in court, you're subject to that stuff being examined. So deal with it. You knew this going in. You certainly knew going in that some stuff was going to get out there. It was going to be public. With your large following and your husband's large following and even your co-star who you're accusing, large following, that this was going to get out there. So now it's the find out phase. You got to just deal with it. Like, you can't make those accusations willy-nilly and then be like, oh, but nothing else needs to be seen. Nothing else needs to be heard. Just listen to what I'm saying. It's fine.
That's a good point. I've heard Omar say this before. Like, when you go into court and you're in trial, you just, as a lawyer, you just want to make your case and only make your case, because if you open the door too far, right, you're sort of going to get off track, or you're giving the opposition a chance to go after all sorts of other things that you didn't intend them to. So yeah, you can't come right out of the gate with the door wide open, because your opposition will take advantage of that legally.
Erica P says it's giving Reddit Dropbox.
Oh, geez. Maybe.
Oh, man. All right. Somebody asked a question up here. Rose as well. Do you think Blake is crazy and really thinks she was harassed, or do you think she's just an effing liar? No, I think that she's not crazy at all, because if she was crazy like really crazy in a clinical sense to where she couldn't be held responsible for these ridiculous accusations she's made, then she would not be able to continue filming in a way that was like efficient and like really doing her job well. She wouldn't be able to keep caring for her kids without issue. She wouldn't keep going about her day-to-day life without issue. Like if there was no problem, if she wasn't like having a psychotic break, if she was really crazy in the sense that lay people think about it when they think about like people who are clinically insane and stuff like that, and people who are deemed incompetent and not held responsible for their actions, we would see a lot more, let's say 2007 Britney type behavior. And we're not seeing that right now. Okay. And don't get me wrong. I love a 2007 Britney, and I'm glad she made it through and she's still alive today.
Justice
But
for Britney, yeah.
that's not what we're looking at right now. We're not looking at a crazy person. We're looking at somebody who's personality, in my opinion, personality disordered and used to getting their way. So
yeah, because there's a spectrum, right? Like it's not just like someone's crazy or not, or someone has a disorder or not. Isn't it more like somebody could have these traits or these tendencies, or sometimes exhibit these symptoms to a lesser or greater degree, right?
Mm-hmm. Yeah, it's you can't just turn it on and off the way that she would have to, I guess. It's like it would severely impact your functioning to the point that other people in your life would notice and they would stop and get you help, and like things would come to a screeching halt because you have to like fix what's going on inside of you before you can function again and before you can behave like an adult again. It's not like, oh, I'm taking a vacation to Ibiza and then I'll come back to filming later. I don't remember exactly where she went when she took that break from filming. But, it's not like that. It's not like a choice. It's not like, oh, shit, well, I feel bad now, so let me take a week off. No, if you're actually crazy, if you're real crazy, you don't get to pick and choose when it happens. You don't get to pick and choose how long it takes to recover. You don't get to pick and choose whether or not you, release your text messages to the New York Times and bite your coworker's lip and accuse him of doing it actually, or and that's something I'll never be able to unsee. Thank everyone involved in that for that, because that was disgusting.
The lip biting thing today.
Yeah, ew.
I saw Dave was covering that. Yeah,
I saw it too, and then I had some people in my comments be like, "Laura, you need to cover this," and I was like, I can't watch that again. It was bad the first time. It was worse the second time, and I'll throw up if I watch it a third time. I'm sorry. There are some things I just can't bother with. So,
well, Lauren, I mean, in your experience, right? Because you evaluate all these psychological issues, right? And if there's people who are sort of like on some sort of scale or spectrum of, whether it's narcissism or whether it's just somebody who's maybe an anxious avoidant sort of personality.
Sure.
My hypothesis is if you took like 10 people like that, you might sort of label them with some kind of label like that, but they might all behave a little bit differently or less or more extreme. So I think it's probably hard to pin it down without a real detailed evaluation, right?
Yeah. Well, I mean, you can have somebody who's incredibly selfish and self-centered and has a high sense of self-importance who isn't a narcissist. And so I feel like that is another term that gets overused. However, in this case specifically, it might be appropriate. It might be appropriate just based on everything that we've seen in the filings and all the things that aren't adding up. And I'm just kind of like, well, this based at plus everything that happened in the past, I'm just kind of like, well, there seems to be a pattern here that you wouldn't see in just somebody who is just like a little flawed. You know what I mean? It's not like somebody who's just like we're all a little imperfect, obviously. But like this is more than that. So yeah, I do feel like a little bit. There's a little bit going on there.
There's a question in chat about our opinion on settlements.
Oh yeah, I was about to pull that up. Hang on. We've heard the lawyer's opinion on a settlement, but what are yours and Bruce's opinions on it? I'll let you go first. What do you think? Are they going to settle, or will somebody try to settle?
I mean, I've listened to a lot of legal opinions here on YouTube, and they all seem to be like, these lawyers would kind of be crazy not to try and settle, colloquially crazy, to not try to settle.
You're good.
So given that, I think that's the most likely outcome, but we'll see.
Yeah. I don't see it. I
No?
don't see it. No, I think
Interesting.
that Sarowitz, the very wealthy man, and the people who have been accused of
Mhm.
horrible, awful things, I think they want their day in court. I
Yeah, I
think,
mean
I think that Blake's side will probably try to settle at some point, and I think they'll say no.
oh, interesting, yeah.
Yeah.
And they'll try to yeah, so they'll say, "No, we wanna carry out a full defense."
No, I
Yeah,
think
that could be
Wayfarer
true.
wants to go to
I
court.
mean
I mean,
the one jury trial, so I was on a jury, and I was, the
you were on a
foreman
jury.
I was the foreman of the jury, and it was a criminal
Is that
trial,
why
and
Casey Anthony got off? Never mind.
no, it wasn't the Casey Anthony.
Just
Oh
kidding.
my
I'm kidding.
gosh. I gotta go talk to her on TikTok, I guess.
Oh,
But,
please do.
the defense so it was the state versus a defendant in a criminal case, and the defendant really wanted to go try and the defendant also didn't have to testify on their own behalf on the stand, and they did. And I was kind of surprised at that because they didn't help their case. And it
Mhm.
was clear that he thought he was helping his case. Like his ego, or like maybe I think like his mom was really pushing him to go testify or something.
Yeah.
And I think maybe the ego can kind of take you there potentially. Yeah. Even though it's not analytically the right move.
Mhm. Yeah. And there's just a lot to unpack here, and especially because there's so many different cases within this case that I like get lost in like who did what at some points. I'm kind of like, oh wait a minute, that wasn't that person, that was this person. So like I'm trying to judge somebody's behavior and actions and what they'll do next, and I'm kind of like, oh wait, wrong party. So it's just a lot. It's just a lot. All right, where did we get to? We went through the mental health records and stuff that they were claiming to be worried about. Okay, protecting one's health. All right, related to third parties. Personal, personal. Here we go. Personal and intimate conversations with really unrelated third parties who have a marginal relevance to this case, where the PR value would be high, but the evidentiary value would be virtually non-existent, and that depends on how you frame it, which side you're on, and where you're going with. Because we're starting talking about
Uh,
personal communications with Blake Lively and Taylor Swift, no doubt.
I mean,
And it's
marginal
kind of like
value is still value.
right,
Virtually
marginal relevance.
non-existent
Yeah,
makes me sound like it exists. Like,
yeah.
whenever you hear these adjectives and this sort of language, it's always a red flag to me because it's like, well, there's you either consider it relevant or you don't, or relevant
Mhm.
enough or you don't.
Yeah. I think I may have missed this before. Sorry, Zach. Thank you for the $2. Ralphie, who is Bruce and who cares about his organ? I don't know. I only care about the cow behind him. So
Oregon.
never met this guy. All right, let's see. We know there will be significant third party discovery because it is, in fact, what was the word they used? Relevant? Yeah. We received RFPs from the parties. What are RFPs?
I think that's request for production, right?
Oh
Of
God,
evidence.
okay. They're designated as confidential by the defendants, so I'm limited in what I can talk about in open court. But I can tell you that there are dozens and dozens of third parties named by name. And so we know that there will be production from parties involving third parties. We know that there will be subpoenas to third parties involving third parties, which those things, again, are not usually made public. So that's pretty standard, in my opinion and in my experience. But all right. And we think there is a significant chance of irreparable harm if marginally relevant communication with high profile third party individuals who are unrelated to the case were to fall in the wrong hands. What do you think we're going to do? Like, we're just going to read them. And the fact is, like, if we read those texts, which are relevant to what you guys decided to bring public, you don't get to bring something public and then be like, no, 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 you don't get to know the details. You can do that in TMZ. You can't do that in court. Okay, you don't get to do that, and then be like, no, 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 you guys don't need to read that. That doesn't need to go in the wrong hands. The wrong hands are just going to read through them and understand what actually happened in this situation, and to be able to form a proper judgment about who is in the right and who was in the wrong here. And otherwise, if you know, stop people from seeing that kind of stuff, it's like anybody could say anything and bring it to a court and then hide the messages behind it and then get their way in the press. So like that's kind of fucked in my opinion. If you really believe that you're in the right, show your messages, subpoena their messages, and say, look at what they did. Look at where he went wrong. And look how my messages are fine. The only reason I feel like you'd be super, super fucking paranoid about that is if you did something that's a little shady.
Yeah, if you didn't have a case. If you can't convince the general public, are you going to convince a jury, or a judge?
Mhm.
You can't have this double standard, right? Well, I can
No.
convince a judge, but I can't convince the public. That's a little sketchy. And I'm sure Anna Kendrick only has high quality, fine things to say, so we'd like to hear it.
That's Bruce's celebrity crush, guys.
Maybe a little. I don't
I don't
know.
know if you knew that. Did you see her little snippet on the red carpet the other night?
I think, well, she didn't really say much, right?
She said something about doing ayahuasca. I assumed it was at your house.
Yeah, we're getting Aaron Rodgers over here. We're going to have a little party.
Aaron Rodgers? Wait, how is he involved in this?
You don't remember? So he quit the Green. Well, or got fired.
Oh, he quit.
He left the Green Bay
Wait,
Packers.
he went to the Jets, though, right?
Yeah. But before he went to the Jets, he went and did this retreat and did ayahuasca, and he's like to decide whether he was going to retire or not. I guess.
Dude, I'd never even heard of that.
I guess the ayahuasca trip told him not to retire, so he played.
What the hell is in ayahuasca?
I don't know, man.
It's just ayahuasca. Okay.
I don't know. All I know is he needs to go play for the Vikings for a season so he can complete the complete trolling of Brett Favre. I don't know.
I don't know. Wasn't Brett Favre? Sorry, I said Favre. Wasn't Brett Favre in Pitch Perfect? Was that him?
It's coming full circle. I mean, yeah.
with Anna Kendrick. Ah! Yeah. Okay.
Crazy.
I'm getting on this. Bruce is Anna Kendrick. Omar is Jenna Ortega. Jenna Ortega is Omar's crush.
I don't know if she's a crush, but Omar thinks Jenna Ortega should be in every movie. Like he thinks.
How fucking old is Jenna Ortega? I'm gonna rag on him for this.
I don't think that's his crush, but
no, I don't. Oh, she's 22. Yikes! Omar's like 70.
Jeez.
No, if he would join us,
motion
he
to
could
compel
me,
birth certificate on that one. I don't know.
He's taking his sweet fucking time, so I'm gonna
What
rag
is
on him as
happening?
much as I want. Who is Lawrence? Lawrence is well, her name is Tammy McIntosh, and she is an Australian actress who Bruce knows from.
Oh yeah.
Yeah,
we're
she's
tight.
very cool. I have let me show you guys. I'm gonna show you guys since you asked. Because I totally wouldn't just randomly pull this out otherwise, because I am totally not like that. I would. Hang on. She's I don't know. I have a lot of Australian viewers or New Zealand viewers for some reason. I don't know why. But she's a friend of mine from these conventions I go to. I edit show reels for this thing called WentworthCon. Let's see. Let me find a good one for you guys. I mean, this one's pretty good. Yeah.
I got to get back into that show. I kind of
Yeah, dude, you gotta finish it. This is a pretty good one. I don't know if you can see it very well.
Yeah, there was a particular thing that happened with B. Smith.
That's a good one. Yeah, I know. We're not gonna spoil it though.
I had a hard time getting back on track after that part of the series.
Somebody says I keep freezing up. I don't know why.
Yeah, there was a moment or two of your video
Really?
freezing. Your audio was fine though, I think.
Well, that's unfortunate.
It's probably just StreamYard being
I mean, if I had to pick one or the other, you see my face still. So I don't know if you missed anything important or not.
You got to freeze frame on a really crazy face. That's the key.
I mean, that's not really a key if I do it all the time, is it? I mean, that's just my resting face. Is like,
oh boy.
Pretend you didn't like that. All right. Anyways, so we got through this. We know that we subpoenas third parties. And so we think this protected narrow category would allow the designation for the communications that have tremendously high PR value, low evidentiary value, and could do irreparable harm that we would suggest this court does have an obligation to protect. Okay, let's see. I mean, as the Supreme Court in Seattle Times said, if information about third parties is released, it could be damaging to their reputation and privacy. Again, you have to think of the little people. We go through this all the time. And the government clearly has a substantial interest in preventing this sort of abuse of its processes. Why is it an abusive process when it's happening to a rich person, but when it's happening to one of us, it's fine? That's what I want to know.
Oh boy.
All right. Let's see. Mr. Learnsky, give me an example of the type of quotes. I don't know who that is. Picking out something. Okay. So I'm not asking you to reveal what kind of communications you're concerned about protecting at the same time as you're trying to protect it, but so that I can give some definition to this particular category. So the judge is trying to figure that out. She says, I understand your honor. Whoa. So let's take a complete hypothetical that I would not have access to. Let's say Mr. And the note is probably wrong here. Baloney. I'm saying that's the wrong thing here. Has a very good friend who is a very high profile individual, and he's venting about his day. I don't know. That might just be how she spelled it, man. I'll be honest. And he mentioned something about our clients in connection with what happened on the film that would be responsive, arguably, that would potentially be relevant. It's on the communication by a party about another party. Okay. But it's value to the case, it's necessity to the case, its evidentiary value would be outshadowed by the fact of who he was communicating with. If he was communicating with a high-profile individual, that all of a sudden creates significant PR intrigue for a communication that to a friend who was completely private, anonymous individual just would, yeah, because that's who we're talking about, right? A private anonymous individual, not Taylor Swift, just would not carry the same kind of weight. That is entirely different, Your Honor, from Mr. Baloney talking with Mr. Sarwitz. Okay. So, this...
I feel like they really need to be specific about the content that they want to protect. For example, in the Owens v. Eckerd case, you could say, well, we want to seal any medical records related to mental health, but we need to examine medical records related to pregnancy and paternity.
Mm-hmm.
And that would be very clear for a judge to be able to go and manage.
Yeah.
Or for the lawyers to go and manage.
Or even Mr. Baloney speaking with another cast member. That is a different type of relevance by nature. Not if you bring them all into it, dude. I mean, how are you going to be like, all these people said this, and all these people, and all is relevant to this, and all this happened on set, and then be like, the cast members and all that communication is not relevant. It's fine. Okay. And they're talking about the Kardashians in a case, which is like legal jargon I don't understand. Let's see. Oh, and then they try to bring children into it. That's right. We're using as examples today because it might fall into this. It's not difficult to envision that there would be the type of materials that are speaking about children or speaking about, profound mental health issues or locations of private residences or homes. You can imagine that there is just a level of personal and intimate information that is particularly relevant because of who these people are. That is an ordinary case, may not be subject to an AEO, but would be in here. So again, why are the ordinary people forced to deal with this, but you are not? That's what I don't understand.
They're famous.
I mean, that's lovely for them. However, if they decide to bring an action to the court and they, make false accusations, not my problem,
Yeah.
Shouldn't be my problem, at least.
Yeah, the judge seems to really be trying to pin them down on specific parameters that you could set conditions on. And I don't know if they're making a great argument here.
Let's see. Oh, God. Okay. I forgot about that part. I'm going to skim over that for reasons I'm not going to say out loud. For the sake of the person who was writing these notes for me, said some words that I'm not going to repeat. Let's put it this way. Let's see. So the judge says a couple of follow-up questions. Why wouldn't your objectives be accomplished by something more narrowly tailored that says the names and PII, personal identifying information? I think that is personally. Yeah. Okay. And then why would it may fall within the definition of an attorney's eyes only. But certain people who are parties, I mean, if Miss Lively or Mr. Reynolds said something about what was going on the set or said something that is relevant to this case, I wouldn't imagine that would be attorney's eyes only. Mr. Friedman, the attorney for Justin Baldoni and Wayfair, the lead attorney, should have the right to discuss that evidence with his clients. Okay. And then the attorney says, well, I appreciate the court's question and thought that you put into this question. I think that it would be too narrow to only limit it to, because, of course, these parties are making their business off of celebrities and people, high-profile individuals. It's highly likely that the content of the communication would indicate clues as to who these people were that would defeat the point of just abbreviating names. For example, if there's a communication talking about, I was at this event on this date, that would divulge a pretty narrow universe of who might be covered by that. Or a communication was, it was so great to see you last night. And we know that Mr. blah, 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 Ms. Lively and Mr. Reynolds are often photographed out publicly. It would not take much to add one and one together and figure out who the party is. So we think that would be too narrow. And we think that the current draft is certainly in keeping with the language of the court's original protective order and just heightens it for a different level of sensitivity and intimacy. So they're saying, like, basically it's not enough, but, like, at the same time, it's like, again, regular people are subject to this shit every day. So why are you more important is the issue. And the judge says, as you know from my model protective order, it's not sufficient to hear the parties with respect to it. The obligations of the protective order don't just apply to the lawyers, they also apply to the party. Okay.
Right.
Oh, there's Omar. Hey.
Hey yourself.
Oh my God, you finally made it.
You like want to stream it like the worst possible times, man. Every single time it's like right in the middle of family time.
Yeah, well, the thing that is the problem for me, though, is that I am always streaming when I have to go to the bathroom halfway through. So, Omar, could you explain to us about you listened to this protective order hearing, right?
I did not.
You did not? I thought you were.
The one that you got banned?
I didn't get banned. I emailed the court and I said, hey, people are telling me I wasn't supposed to record this. Should I take it down? And they said yes. And I said, oh, okay, no problem.
Lauren Neidigh, because of you, we have now lost access to the entirety of these court proceedings because of your irresponsible YouTube posts. I'm kidding. Obviously, you didn't.
Anyways, I need you to talk about so you didn't watch any of this?
I didn't listen to the hearings, no, but I have a pretty good idea what's going on.
Okay, well, can you talk to Bruce about what's going on while I pee for a second? Because I really have to go to the bathroom.
All right, Bruce. How about you fill me in what you guys are having conundrums about?
Well, I mean, so far we're mainly talking about how they want to sort of, have this broad protective order for various issues, right? So there's, they're mainly hammering on this issue of, hey, these are celebrities. They're talking to other celebrities. That's part of their business model. I mean, what is your take as a lawyer in terms of the breadth or the judge's discretion on the breadth, or, can a judge a la carte redacting or protecting certain information in the case?
Well, it's delicate. So this is not a case that involves things that are normally shielded from the public. You got vague sexual harassment claims, but really the majority of it is just a breach of contract suit, defamation, slander, false light type of lawsuit. Those are not the kind of hearings that are normally protected from the public unless there's an actual threat. So like the last motions that I saw, everybody's talking about how there's been actual threats to some of the main prospective witnesses, and for those reasons you're trying to keep them under wraps. But you can't. I mean, these are public figures. I think this is probably the most famous court lawsuit going on right now. Mm-hmm. Everybody knows all about it. People know more about this than they knew their own cases, I'd venture.
Yeah.
And so there's some anonymity with some of the prospective witnesses. And I'd imagine that the orders of protection that they're trying to assert are geared towards protecting them. But then
Mhm.
you have to show like there's some real dangers. Like, okay, so there's some threats. What are they? And I don't know if they identified any threats in this hearing. Um,
I think it
that
was a little vague. They mentioned sort of news articles and social media accounts and things like that.
Yeah, if that's the case, me too. I get threats all the time on social media and through emails and stuff. So BFD,
Yeah.
man, it's got to be like some kind of a credible, like actual threat. It
Mhm.
can't just be like one person in Cambodia
Mhm.
sent you a mean text message or an email
Mhm.
or posted some bad thing on X
Mhm.
that hurt your feelings. That's not what it is. Death threats where people like doxing you, getting your addresses, that's a little different.
Mhm.
But look, court proceedings are public, even federal ones. Even if you're not allowed to broadcast them on YouTube, the court
Mhm.
makes them available for at least some of these hearings for public consumption. And even then, you get the transcripts at the end. You get to talk about the results. And if the court's not doing it, the attorneys are not bound or banned from doing that.
Mhm.
And so you have to be very careful, I think, as a federal judge to weigh First Amendment protections of the lawyers and their ability to try the case. Not that they're trying it in the public, but they have every right to conduct public relations.
Mhm. Now,
Like
what about
if they're,
yeah? So for this security argument, like in my mind, like if I was if we were talking about these celebrities and they have a security detail, and the security company has like a business plan, a security plan, like Steve's going to be at the back door from 8 to
yeah,
12, whatever, right? Maybe these are things you don't want released publicly, right?
sure, but then you
But
just
but if
redact stuff.
yeah, but if it's like a security guard who was there for a conversation and they need to testify about the contents of the conversation, that's not exactly a security concern, right?
No, no, it's got to be security stuff that like leads to real physical harm, put
Hmm.
somebody in actual peril. It can't just be like these are protected communications, unless they're privileged, like attorney-client communications. Those are privileged. You don't ever get to know about those.
Okay.
Matter of fact, if an attorney like writes notes about strategy for an upcoming case or how we're going to cross-examine a witness, you don't get to read those notes. But
Right.
if there was communications between prospective witnesses, that's not privileged. That gets to come in. Matter of fact, if it's relevant to the case, it might end up becoming evidence. And if you want to argue hearsay, fine, but we still get to depose whoever the declarant was to figure out what was going to be said, whether or not it's relevant or not. A lot of things. And we don't know what's going to be relevant or not until we conduct discovery. And to that regard, privacy is not really a thing unless it falls under some kind of a privilege that makes it so, such as medical records, such as attorney-client privilege, and those kinds of things.
Hmm. Okay. So medical records, attorney-client privilege. What about trade secrets and in terms of like business?
Sure, that
Um,
would be one of them. But like, at what point is trade secrets in this case going to become relevant? Because what they're looking for is evidence of a conspiracy to run a smear campaign, right? And
mhm.
there's evidence on both sides that might have been going on, that people might have been making plans to plant false stories or sell false narratives to damage the reputations of various individuals. In the
Mhm.
course of conducting discovery, is it possible that you might run into the trade secrets of some of the media outlets? Sure, but they're the ones that are going to have to argue that in court and prove that it's a trade secret that is worthy of being protected, or you're going to be prejudiced in somehow, or it's going to cause you whatever damages. Because if you can't prove that, then it's not,
Mhm.
and it's discoverable.
Okay. And in this, I'm not familiar with the federal law, but how fine or coarse grain can they go? For example, in the Owens v. Eckerd case, Judge Mata said, hey, look, if there's very specific medical records about mental health, we can, seal those or keep those private. Whereas
Yeah.
we need to see all the medical records related to pregnancy and paternity, right? So how
Well,
coarse grain or fine grain can they go in this case?
medical records are not like absolutely protected.
Hmm.
If there's a good reason to reach into them, that's for something that's relevant to a case. For example, in a criminal case, like if there's DNA in there that they need to extract, they're going to get a warrant for that. You don't get to say, hey, that's my personal medical. You can't just steal my DNA. Yeah, they effing can if they have a reason to do it. And they can do the same thing in family cases and civil cases, federal civil cases, all those kinds of stuff.
Okay.
And so how fine can they go? They could go as fine as they need to, so long as it's relevant to a cause of action. And right now it's very particular. And the burden is high because they're trying to prove conspiracy.
Mhm.
That's more than just a preponderance of the evidence. They got to prove through clear and convincing evidence that there was this plan that was orchestrated on either side to fundamentally take down the reputations of Blake Lively or Justin Baldoni or any of these other characters or Wayfair or Sony or whoever, the New York Times. Somebody was conspiring and we need to figure out who the players were. So how fine do we need to go? Should we go into the metadata of the text messages that were sent between the relevant parties for the relevant time period, which if we're talking back to October, I've been led to believe is somewhere in the tens of thousands of text messages between like 100 different individuals.
Yeah.
So we could get like molecularly deep if we need to. The question is any of the things that are going to be discovered trade secrets? Well, that's why they pay the attorneys like $1 million a month on both sides to figure all that shit out.
Mhm.
Yeah.
Okay.
And not to interrupt, but
Oh, yeah, go
I was
ahead.
on my way back, and then I found Steve outside the door at 8:12. So
What? Steve
What's
Cheese?
up, Steve?
you guys don't remember that conversation you had 5 minutes ago? You said something about a security guard, and then you were like, "It's Steve. He's outside the door at 8:12."
Oh, yeah.
Steve from Jerry Springer, that guy?
No, Steve from Bruce's Fantasy.
That was my made up security guard.
Oh, like Chad Brockington?
Yeah.
I've lost my beverage.
I
I
have
hear
a little-
children.
I know. It's family time. Omar's pumping.
It's totally out in the open. I don't need a cover. I'm
Now
just
we
it's
know you
all
can't
hanging
just
out,
be
man.
invited, and that's fine, because even if you're invited, somebody might sue you.
Well, I'll just give you permission and then sue you after the fact and say that you were trying to cop a look.
I was gonna ask if I could have some milk, but that's fine too.
Oh, jeez.
Pretend you didn't think of it first.
Bruce thought of something much worse. He just knows better than to say it out loud.
Oh, for sure.
I try to be classy, like Audrey Hepburn.
Well, on Lauren's stream anyway.
Yeah.
On Flat now.
Yeah, because I'm so classy, dude.
Okay, so
right.
okay, we talked about security. We talked about trade secrets. What's next, Lauren?
Let's see. So I think they let him eventually respond after all of that. Hang on, let me see. Because Omar, I don't know if you know, I have this pretty detailed note here. I had somebody else take notes for me because my ADHD was running wild throughout the hearing. So
during the hearing, why don't you just transcribe it?
wait, why didn't they just transcribe it? Because
no, you like transcribe it through your phone. Like, doesn't your phone do that?
I don't know, but I was freaking out trying to get it to work in the beginning, and then I had the phone up to the microphone.
I did see you stumbling around, and then I saw you with Dave's stream. He's like, why is she like live streaming Dave? And then I had to like go to court, and so that was the end of that.
Yeah,
That's
I know.
where
I had to
kind of
put
pulled out.
him on because I couldn't figure it out in the beginning, and so that's when I missed the part of the hearing where they were like, "Oh, by the way, don't record this."
I just caught the tail end where like you were freaking out. Well, you weren't freaking out, but you were like chastising negative commenters for somehow foiling the public's access to this very crazy case. Single-handedly. Who knew? Lauren Neidigh.
Me with the less than 20K followers. Yeah, I'm sure I ruined it for everybody. I don't think they would ever even have known about it if I hadn't emailed the actual judge's chambers and been like, "Hey, by the way, is this okay?"
Yeah, I know. I'm pretty sure like nobody else thought to do that. Like Dave Neal did the same thing. He took it down. I don't know if he like emailed the judge the way that you did. Like you did everything you were supposed to do. You could have possibly done. Although I did track when I heard it on your streams, like, hey, the recording of these proceedings shall not be transmitted through. And he's like, oh shit.
Yeah, I completely missed that. So, yeah, I don't know what was going on in the beginning there. I was just like freaking out trying to get my phone to work because I was like, well, if I can't get my phone to work, everyone's going to leave my stream and then I'm going to be sad. So I better figure this out. And I don't care what anyone else is saying in the background right now. So, yeah. Because I took work off for that. I like started work late and worked late that night for that. So I was like, I gotta I gotta get my shit together. Hello,
You too,
child. Who the hell is that?
Dad, sister breast things.
Why?
Oh boy.
What did she
I'm
do?
sorry.
Go brush your teeth.
Who didn't brush your teeth?
Sister.
Evelyn?
It was definitely Bruce.
Next week we're going to teach Omar about the mute button.
Oh.
That'd be great, dude.
Well, y'all want to stream during family time, so.
That's how it goes.
I'm sorry. I thought brushing teeth was also a thing during family time, but apparently not.
That's during morning time and like nighttime. Never mind.
Dude,
morning.
you better do that more than once a day, homie. Like, what are you talking about? Like, do not teach your kids to only brush once a day.
Well, they do, you know, the wife and stuff. She
Take
teaches
care of
them
those
those things.
teeth.
They need to bathe themselves. They got bigger problems.
Oh my god,
These little walking germs.
Oh boy.
I'm scared.
Jam hands are ongoing.
Little petri dishes. Hey, folks, I got to go, man. I'm already
Hi.
getting stink eye over here.
I don't know what that means, but okay.
Bruce knows what it means.
All right, Omar, before you go, if there are multiple cases going on here, right?
Yeah.
And I think some of them may have been merged together or whatever.
I think it would be like really helpful to draw like a map of who's suing who for what.
Get the string map
Yeah.
on the wall. Yeah. But if you can't just like, I don't know, if you get a subpoena in one case, you can't just use it in another case, right? What if the cases get merged? Is that then do they go together or how does
Well,
that work?
it's like this. Everybody's getting sued, but not everybody's getting sued for the same thing.
Yeah.
That opens up the scope of discovery to like, you know, an enormous search area, right? And not all of it's going to be relevant to all of the parties. And so if it's relevant to one defendant, it's relevant. And if it comes out in the trial in the course of being litigated amongst all of these co-defendants, it's going to be for public consumption. It doesn't mean that it's going to necessarily affect everybody else's case.
Okay. But that's once it becomes part of the public court docket, right?
Yeah. I mean, obviously there's things happening in discovery that is not 100% going to be disclosed to the public. Like just because you get answers to things like there's requests for admissions and other stuff, you know, especially if you're arguing privilege, you don't just get discovery responses and then just like publish them to YouTube or something, right?
Yeah.
Now there's obviously exceptions to that.
I totally wouldn't do that.
But you know, depositions and stuff, that's usually fair game to release those. And there's usually agreements. And if somebody objects to it, they can. And I suspect they're going to try to keep depositions under wraps. I'm not sure if they're going to be allowed to. Doesn't seem like they are. But yeah, all of the discovery that is being conducted right now is relevant to every single cause of action for every single participant in the litigation. But obviously not everything that's uncovered is going to be relevant for every defendant. And so we're just going to get a whole lot of shit and we're not going to know what's what until we put it all together. That's why, especially in a case like this is complex litigation. You have to build a map of where the causes of action, who they are affecting specifically, who's on the hook for what, and all those kinds of things. And then the lawyers are going to they're going to take that map and they're going to attach to it specific pieces of evidence. And, you know, it's like a big puzzle. They're just going to put it all together at the end.
Mm-hmm.
Right now, we're at the accumulation stage. We haven't even started putting it together. I mean, they might have started, but they're nowhere near being finished.
All right. Very good.
So we're close.
Thanks, man.
We're closing in on something. I don't know what we're closing in on, but it's something.
All right, man.
Thanks, man. Have a good night.
Thanks.
All right, man. Love you guys.
Love you too.
Take it easy.
Take care.
All right. Let's see. I'm trying to remember if there's anything because I know Friedman came back at all this stuff, but I'm trying to see if there's anything weird on the other side that I'm missing. Mr. Friedman, no one from Steam. Okay. Okay. Hold on. This is very specific. Hold on. Okay. So somebody says, yes, Your Honor, I have 8 very discrete points. 8 very discrete points. I'll start with the low-hanging fruit. As far as paragraph 16, I think we can all agree the intent of this provision is not to prevent the emailing internally. it's to prevent the publication of any confidential discovery information on the internet. So this is Blake's attorney fighting back against Brian Friedman, who said basically the AEO designation would prevent them from even, internally emailing with their own people. We would be happy to propose modified language. Well, modify this. Or better yet, we'd be happy for Mr. Friedman to provide modified language to us. He never objected to this or provided any suggestion that there was an issue or alternative language during the conferral, so we'd be happy to consider alternative language with respect to his accusation about publicizing his clients' addresses. My understanding is that those addresses were pulled from publicly available sources, and so they were already in the public domain, but separate. So what's the issue with your stuff then? All right, let's see. And perhaps more importantly, Mr. Friedman or no one from his team ever informed us about improper disclosure. Of course, if they had, we would have properly addressed it and considered the point. 3 of 8, Jesus Christ. Mr. Friedman made some remarks about his attempt to limit the number of third parties. Again, I am restrained by their own use of the confidential designation on their archives, but I will represent that there are dozens and dozens of third parties specifically named and identified, even up out there, specifically named. So he knows full well that there will be many third-party privacy interests implicated in his own request. I mean, what privacy is really going to be violated here is my question, I guess. Oops. Hold on. Accidentally closed out the... Okay.
Yeah, I mean, we already know it's a large case with...
Yeah.
I mean, it's not a surprise there's a large list of potential witnesses.
Everybody pretty much knows who's involved at this point. So, third-party privacy interests implicated in his own request. Number 4, I think there is a false assumption here that is predicating all of Mr. Friedman's arguments. He's assuming that Ms. Lively and Mr. Reynolds and Ms. Sloan and Vision PR will be the only people availing themselves the attorney's eyes-only designation. This does not pose a burden uniquely on him. He said many times we would have to go to the... Okay, they would be availing themselves of the provision just as they already have availed themselves of the confidential provision before a PO is even in place. Protection order. So, and not to mention there are third parties. They are just assuming that every third party who designates attorneys only will be someone who they are contrary to. It may be, in fact, that we have issues with third parties over designation or use of the AO provision. So the process that's contemplated here is not placing an unfair burden on him. It's the exact same burden as to every individual. I feel burdened by the fact that you're only on 0.4 of 8, bitch. All right.
Lawyer and...
God, good Lord. So the judge says, you're not making the argument to me that there shouldn't be an attorneys only category because you want to share information with your clients, are you? She says, no, I'm not. No, I'm sorry. I'm not making that suggestion. What I'm saying is that he was arguing that having to come to the court to de-designate places places a different burden than the one established in the protective order, as if it would be uniquely placed on him. I don't think that that's a unique burden for him. Every party will have that when they disagree with and then it cuts off, so I'm not sure what happened there. I also think Mr. Friedman made it our point for us, and it's difficult to understand why we're here. What is our subset of number 5? Jesus Christ. 1, he's attempting to create a whole new process, or as Your Honor noted, is essentially the AO process. So rather than have to take their words for it or give them the benefit of the doubt or trust them, it should just be memorialized the way we proposed, and related to that, he agrees that health and medical records would be AO, that security would be attorneys only AO. So here he has admitted that there shouldn't really be a dispute over the types of categories we've been discussing today. And then the judge interrupts. So can I take that it would satisfy your concerns for there to be a protection order in place that has a category that is a claim of attorneys only, but that if you don't come to the court within a certain period of time and you don't justify whether it is an incremental, unacceptable harm and disclosure to the parties themselves, would that lose the claim of AO? The judge again says, am I correct? Does that satisfy your concerns? And then the attorney says, I don't think that would satisfy my concerns, Your Honor. First of all, I've never... That's it. Okay. Most of the cases, respectfully, that I've done, set it up this way where you can. I agree with designated as AO, meet and confer. If they want to be designated, they can be like, that is the typical process that is the common in my practice. I fear that, and some of these notes are jarbled, guys. I fear that doing it this new way, especially on the fly, without actually seeing the language or how it would work, because again, we were never proposed with this option during the conferral process. I fear that this will just create the same challenges and problems we had with what was in the model protective order, which it would make us have to come over to the court in a piecemeal ad hoc way, as opposed to at a point when designation makes sense. Okay, guys, I remember this now, because I remember thinking this is like egg salad, but with words. I don't understand what she's saying here. So, I don't know. Bruce, did you get any of that? Did you understand any of that? This is the point where I think we were all kind of like commenting and saying like, what?
Yeah, I'm trying to think back. I mean, yeah, it would help if they would just say, look, this is where we are. This is what we want. Here's why.
Yeah. No, there's
and I know they're
weird
speaking
shit going on there.
extemporaneously, so it can be a little challenging.
Yeah, I don't know. I remember this lawyer in particular at this point started talking like a crazy person. Not in the sense that she was saying crazy things, but that she was just saying words. And I was like, what are you actually talking about? And I get it, I do, because I don't do constructive speeches very well. But like at the same time, I was like, you're a fucking attorney. What are you doing? You're like a very well paid attorney. What are you doing? Do better.
Yeah, it would have been a little helpful if they'd had a more concise summary of exactly what they were asking the judge for here.
There's just a lot of craziness going on there, man. All right, let's see. Words.
Mm-hmm.
Hang on, so I'm just trying to get to the next page. Okay, so they're talking about the opposition to this attorney's eyes only designation. They're saying it was criticizing casting assertions, which I won't go into, and then it was a single paragraph that amounted to claiming that Ms. Lively had no privacy interest because she had chosen to defend herself and speak out against claims of sexual harassment. I respectfully suggest, Your Honor, that we are dubious of his claim that, quote, no doubt we will be reasonable if their starting position is that a woman who speaks... Oh, God, here we go. You're a cunt. I'm sorry. This lady who's saying this, you're a cunt. You don't speak for women. You do not speak for women, especially like your client who has put forth claims that clearly are not entirely accurate. You're a cunt. I didn't say that before because I was in the middle of the hearing and I was just doing sign language to call you a stupid bitch or whatever. And I want to say now, you're a cunt for this next thing I'm about to read. Okay. I respectfully suggest, Your Honor, that we are dubious of his claim that, quote, no doubt we will be reasonable if their starting position is that a woman who speaks out against sexual harassment is entitled to no title. And finally, let me assume that everybody's going to be, we would hope so, Your Honor. Finally, I just wanted to, it's my assumption, and she's tripping over her words here. Stop being, go ahead. Well, I can commit to that. And finally, my last point is Mr. Friedman started his argument with saying that we are asking to be treated differently. Well, aren't you? Are you not asking? Okay. Good Lord. And there's like a lot more of this, guys, but I'm not going to go through the rest of it tonight because I am extremely tired. I'm thinking about getting the official court transcript where it divides everything by who was saying what, and it's actually like a thorough transcript. However, I would have to pay for it, like I paid for the February 3rd transcript. So I'm going to try to see if I can pool some people together to like pay for those documents tomorrow. I'll make the request tonight and ask for an estimated price, and then we'll see where we go from there. But I'm not going to pay for that all myself again, because that was crazy. All right, guys, that's it for me tonight. If you want to donate to the document fund, my Venmo link should be in the description of this video. And I will let you guys know tomorrow what's the deal with the transcripts, because I know I can request it now, but I don't know how much it's going to cost, because if you get the first copy, it costs a lot more. And if you get it in a fast time frame, it costs a lot more. So it just depends on when you get it and like what number of line you are. Yeah. So like people, I guess media people had gotten some copies before me last time. And then so I got it within the 2-hour delivery time, but so many other people had gotten it already that was just a copy. It wasn't like they had to do an original PDF or anything like that. So yeah. So
yeah, it would be easier to see some of this in writing, I think, because we could really tease out, like, where are they making assumptions or claiming assumptions? Where are they generalizing? Because I think the problem we had with that last section was really this. You're not making an argument about what you want in this hearing. You're just sort of generalizing in order to evoke emotional response, which is kind of a red flag for me when reading that. But we'd have to see the actual transcript, maybe.
The actual transcript would help a lot. I mean, these notes are kind of like, they're very good and thorough, but they're also kind of jargony at some point. So I'm like reading them and I'm like, oh God, this is terrible.
Yeah, I mean, I kind of remember this. This one lawyer was talking pretty fast at this point.
Oh yeah, no, and she, are we talking about a lady? She's a lady.
I think so.
Yeah,
That's the section we were in.
She was word salading all over the place at one point, so that was pretty bad. But yeah, anyways, a Cash App. We've been over this before, but not since I had new followers. Cash App, I don't use Cash App for a reason, guys. It's because the only time I ever used Cash App in the past was 4 or 5 years ago when I was in grad school, and I thought it would be interesting to try to sell feet pics. So I have a fake name on my Cash App account. I don't want to send it to anybody, so I don't use Cash App. At least I'm honest about why. Yeah, I don't want to give up my scam from 5 years ago. I don't do that anymore. But
Wait, you don't do it anymore, but you don't want to give it up?
No, I don't want anybody to ever trace any of that back to me. What if one of those crazy dudes that I scammed with my feet pics, pretending I was a sorority girl,
you could
then watched my YouTube channel and was like, "Oh my God, you're not a hot sorority girl."
Oh, can't you make a different account or something with a different email address? Or
yes, Stephanie, you can post my Venmo.
Good golly,
dude, look, I was in my 20s still. I was young. I'm 32 now. I'm almost at death. It's like,
I mean, maybe there's a deal. Like we can get like the court transcripts for a discount if they come with some feet pics or something. I don't know. Maybe there's something we can work out.
Chasing charlatans. Wait, did you make good money doing it? I made a couple $100, and then sometimes I would just ask the people to send me DoorDash from Baskin Robbins or something like that. And I know that was irresponsible because I gave them my address, but at the same time I was just kind of like, you're never gonna come here. And then I moved, so it didn't matter. Yeah.
Feet for ice cream.
Yeah, Stephanie has the doc fund right there. But yeah. So if anybody wants to contribute to the doc fund, please do. How much would the transcripts cost? I don't know yet. I'm emailing them tonight, and they won't get back to me until tomorrow because they're obviously out of business after 5 p.m. So it just depends on the order of things and how fast I want to get them. So we'll see. Wow, and you judge Jen Abel so hard. Well, yeah, she did a lot of really No, we're not going to use that word. No, I said reptar. We're not going to use that word. She did a lot of really stupid things. I don't use that word, guys. I catch myself. Okay. But she did a lot of really stupid things. So yeah. I'm in my 20s. Should I do a feet pics? Yes, send them to me, please. And then copy Bruce on that.
Oh, jeez.
But only if you get your toes done first, because that's nasty if you don't.
What? Like a
Yeah.
pedicure?
Yeah, like a pedicure or like even do your nails yourself. I don't care. I just don't want to see like the feet that look like mine. If I see feet that look like mine, I'm sending them to Bruce's
Well,
mother.
I mean, you already have your own feet pics. You don't need more.
I do in fact have my own feet pics. I'm sure they're on my cloud somewhere.
Oh boy.
I'm not kidding. I have photos going back to like 2015 or something on there. So yeah. Yes, she did, but you gave your address to foot fetish peeps. Yeah, but nothing bad happened to me, and I didn't take those people to court like a moron. So I'm good. All right.
Oh boy. We got a lot of work to do.
Yeah. Only a hand hug flower. Thank you, Palaver Girl, for the 2. I don't know what that means, hand hug flower.
It
Only
seems
a
nice.
high five hug flower. I think that's a good thing. I'm not sure. But Nita Black says Lauren just book a petty appointment and live stream and sketch.
Whoa.
That's not my game anymore, man. I'm not a young person anymore. I don't do the young person game. It's the foot game. I'm not into it. I'm more on selling my sarcasm now, but if I maybe when I hit a little
Well, now that they have super chat goals, you can it could be like each toe is a super chat goal.
I could do that. I could
That could
wait
be
for
a
my.
thing
I could
for
also wait
someone.
for my midlife crisis because I'm just not ready for that. I'm not. I'm not as strange as I used to be, and I'll get there again. Don't worry, but I'm not there yet. So.
That's a low bar.
And now I'm hearing a lot about people's feet shapes and stuff, and I'm ready to go away. All right, bye everyone. Thanks for joining us, and I will see you tomorrow. Like I said, we'll talk about that transcript, but I have to kind of crowdfund that because I've been paying for a lot of documents recently, and it's been very expensive through the LA Superior Court for that last lawsuit in 2020 that we did some research on, and then between these also, it's just like so. All right, everybody, thanks, and I will see you soon. Bye.